Get ready for the dictation. Start. A counter affidavit has been filed on behalf of the Union of India, also stating that the report, as envisaged under Section 3(5) of the NSA 1980, forwarded by the Government of Uttar Pradesh by a letter dated 1/2/2021, was received in the Ministry of Home Affairs on 8/2/2021. The same was examined in detail along with the documents attached therewith by the Deputy Secretary, Security, who noted that there was no reason to interfere with the said detention order. A copy of the representation dated 13/2/2021 of the detainee, along with para-wise comments of the detaining authority, forwarded by the District Magistrate Shahjahanpur by the letter dated 15/2/2021, was received in the Ministry of Home Affairs on 18/2/2021 and on 19/2/2021. The same was processed for consideration of Union Home Secretary. Being aware of the effects and sensitivity of detention under the NSA 1980, the representation was duly considered at various levels to ascertain the merit. Thereafter, the Union Home Secretary, having carefully gone through the material on record, including the order of detention, the grounds for detention, the representation of the detainee, and the comments of the detaining authority, thereon concluded that the detainee had failed to put forth any material cause or ground in his representation to justify the revocation of the order by exercise of the power of the central government under Section 14 of the NSA 1980. He therefore rejected the representation and the detainee was informed via wireless message number 2nd/15028/25/2021 NSA dated 24/2/2021. Opposing the merit writ petition, Sri Sayyid Ali Murtaza, learned AGA, has submitted that there is no thumb rule that the preventive detention can be ordered only if a bail application is pending. Its genesis lies under Article 22 of the Constitution of India. However, normally preventive detention is ordered only when a bail application is pending. As the petitioner was already in custody in a case under Section 302 IPC, the NSA 1980 was not invoked. The cause of action for invoking the NSA 1980 was that the petitioner was granted bail in case crime number 837 of 2019 and case crime number 873 of 2019, and he had filed an application for bail in the case under the Gangster Act. He has submitted that whether the case involves a threat to maintenance of public order or law and order depends upon the facts of each case, and the order of preventive order has to be passed by the detaining authority on the basis of his subjective satisfaction in this regard. Mr. Murtaza has submitted that the incident took place at a public place, due to which the PWD office and the nearby shops were closed, and the students of college situated nearby got panicked, and therefore it involves breach of public order and not merely a law and order. He has submitted that the detention order NSA 1980 can be passed in any of the following conditions if the accused is not in custody or when he is in custody, the detaining authority is satisfied that he may be enlarged on bail where no bail application is pending. In response to the petitioner's contention that the entire relevant material was not provided to him, Sri Murtaza has submitted that although the detention order refers to the two criminal cases bearing case crime numbers 837 of 2019 and 873 of 2019, but it is not a ground of the detention order and it has not been relied upon by the detaining authority. Hence, the first information report of these two cases was not a relevant material required to be furnished by the detaining authority. The bail applications filed by the petitioners regarding these two cases were his own documents, and therefore the petitioner did not suffer any prejudice due to non-supply of the bail applications and the connected documents. The material is to be provided because it would affect the satisfaction of the detaining authority regarding the grounds of detention, and secondly to enable the detainee to make an effective representation. The criminal cases pending against the petitioner were not going to affect or change the mind of the detaining authority. Sri Sayyid Ali Murtaza has further submitted that even if the court comes to the conclusion that the relevant material was not provided to the petitioner, it would not affect the validity of the detention order because the detention order has been passed on many grounds and not on one. Section 5A of the NSA 1980 provides that the detention order shall not be deemed to be invalid or inoperative merely because one or some of the grounds for passing the detention order is vague, non-existent, non-relevant, not connected or not proximately connected with such person or invalid for any other reason whatsoever. Stop.